Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps the channel grow. For today's case, we are dealing with searches at the border of cell phones without a warrant. This is the case of Ghassan al-Assad versus the Secretary of Homeland Security from the First Circuit. In this case, people were moving through the border checkpoint, and the government wanted to search their cell phones, including the data therein, for contraband and other criminal information. And the people object, and the First Circuit has to decide whether or not this would be acceptable or not. So we're going to learn a little bit about border searches, what the nature of consent is, what the nature of warrants is, what the nature of process is, and all the rest of it. Let's get started with this. The customs policy distinguishes between basic and advanced searches. It defines an advanced search as any search in which an officer connects external equipment through a wired or wireless connection to an electronic device, not merely to gain access to the device, but also to review, copy, and or analyze its contents. Advanced searches require supervisory approval, and under custom policy may only be performed in instances in which there's a reasonable suspicion of activity in violations of laws enforced or administered by the Customs Patrol, or in which there is a national security concern. A basic search, in contrast, is any non-advanced search, so presumably something that doesn't put an external device connected to it, principally. For both basic and advanced searches, custom policy allows only officers to search information that is resident upon the device, so nothing from the cloud, and devices must be disconnected from the internet before the search is performed, which kind of makes sense because if it's in the cloud, it's not on the device, and we're only concerned about the device, so fair enough. In addition, the custom policy states that an officer may detain electronic devices for a brief, reasonable period of time to perform a thorough border search. As to the merits of the Fourth Amendment challenges, the district court first held that basic and advanced searches are both non-routine searches, and thus both types of searches require a reasonable suspicion. The court concluded that the basic search component of the policies violated the Fourth Amendment. As to long-term detention of plaintiffs' electronic devices, the district court held that devices detained based on reasonable suspicion could only be retained only for a reasonable period that allows for the search for contraband. The Fourth Amendment forbids unreasonable searches and seizures. In the absence of a warrant, a search is reasonable only if it falls within a specific exception to the warrant requirement. One such exception to the warrant requirement, recognized from early in our history, is the border search exception. The exception is grounded in the government's inherent authority to protect, and paramount interest in protecting its territorial integrity. Plaintiffs rely on Riley v. California to argue that the border search warrant exception does not encompass the search of electronic devices because such searches do little to advance the underlying purpose of the border search exception, when they say are limited to interdicting contraband and preventing the entry of inadmissible person. The argument rests on a misapprehension of the applicability of the holding of Riley. In Riley, the Supreme Court held that search incident to arrest exception to a warrant did not extend to searches of cell phone. In doing so, it reasoned that individuals have a heightened privacy interest in their electronic devices due to vast quantities of data that may be stored in these devices, and the government's interest in searching a cell phone during arrest was limited because searches do not meaningfully advance the search incident to arrest exception purpose of protecting officers and preventing destruction of evidence. Contrary to the plaintiff's assertion, Riley does not command a warrant requirement for border searches of electronic devices, nor does the logic behind Riley compel us to introduce one. As recently explained by the circuit, Riley did not either create or suggest a categorical rule to the effect the government must always secure a warrant before accessing the contents of an electronic device. Okay, so now we have to talk about this case Riley from a couple years ago at the U.S. Supreme Court and its applicability to the current situation. That's the legal question. And the court is right in some of what it says. There's a new domain in which it has to be considered. So what did Riley hold? Well, Riley dealt with the search incident to arrest. So you're being arrested for whatever reason, and they have the right to search you as incident to that arrest. So they can search your person. They can search your car if you're arrested in your car. They can conduct a search. And one of the things that might be on your person or in your car, for example, might be a cell phone. And so the question was, well, what can they do about the cell phone? Can they search the cell phone itself? And then you got into whether or not the cell phone is the same thing as a container or not, which was part of the discussion because it was the only analogy we had to work from. But it didn't really matter in the end. The Supreme Court just simply made a determination that a search incident to arrest does not allow you to search the contents of a cell phone. You might be able to do it through a warrant, you might be able to do it some other way, but you can't do it just, automatically. And the Supreme Court said because the nature of cell phones, the nature of data, and because there's nothing that you're going to find that's going to help you or protect your safety or be relevant to the immediate need for the search incident. So it doesn't make any sense. So the First Circuit has to consider the question of how does that apply, if at all, to a border search. So it's not exactly being arrested. You're not arrested. You could always presumably leave and go back across the border. And even if it's more like a detention, more like a Terry stop anyway. But it's a kind of a Terry stop without reasonable suspicion because that's how things work at the border. So the question is, here, can they search the contents of a cell phone? And the interest is a little bit different because in the search incident to arrest, you're primarily searching for things that might be dangerous to the officer's safety. You're primarily worried about destruction of evidence, but those concerns can be dealt with later. In the case of crossing the border, you're worried about stuff on the cell phone that might inherently be illegal. So you're not worried about it being dangerous as such. You're worried about its illegality and it's being imported in the United States. So does the search incident rationale of Riley apply in this situation or not is a reasonable question. It depends how you parse the Supreme Court's opinion. If you parse it basically on the idea that cell phones are different fundamentally, then it would read on. If you read it more in the limited context of arrest, then not so much. And so the Court of Appeals here reads it more limitedly, which is reasonable, but it's not necessarily clear it's correct. And of course, the Supreme Court will almost certainly have to figure this out one way or another eventually. But it's a reasoned decision, if not maybe the one we want. Further, given the volume of travelers passing through our nation's border, warrantless electronic devices searches are essential to the border search exception purpose of ensuring that the executive branch can adequately protect the border and also prevent the importation of illegal or dangerous goods, which might include things on a cell phone, to be quite fair. Every circuit that has faced this question has agreed that Riley does not mandate a warrant requirement for border searches of electronic devices, whether basic or advanced. The 11th Circuit has held border searches have long been exempted from warrant and probable cause requirements, and the holding of Riley does not change this rule. The 4th Circuit held after Riley that law enforcement officers may conduct a warrantless forensic search of a cell phone under a border search exception where the officers possess sufficiently individualized suspicion of transnational criminal activity. The 9th Circuit, noting that even post-Riley, no court has required more than reasonable suspicion to justify even an intrusive border search, held that both the basic and advanced border searches may be performed without a warrant or probable cause. Agents may perform routine searches at border without reasonable suspicion. Under the circuit law, certain non-routine searches must be grounded in reasonable suspicion. Okay, so the other factor that you have to consider in adjudicating this as you're trying to determine the law. So the other factor you have to consider is that the border might be the absolute zenith of governmental power. The government can do things at the border that they can't do anywhere else, including like within the United States. The border might be the absolute zenith. The government might even be able to break certain constitutional rights at the border, or at least you can have an argument about it, because that's how expansive the border power is. Because it's one of the fundamental aspects of being a country, right? So like what's the definition of a country, right? Well, the definition of a country is like a territory, a population, and the ability to defend your borders, and also recognition from other countries. That's basically the 4 requirements. So the idea of being able to protect and control your borders goes pretty far deep into the concept of what makes a country. So yeah, the idea that the Constitution may not fully apply at the border is not exactly insane, because the power at the border might be as big as it gets. It might be one of those fundamental constructs of sovereignty. And the idea that they might have the ability to search you and Riley doesn't apply, I mean, obviously you can think it does apply. You can obviously think it does. So I'm not telling you have to think that Riley doesn't apply here. I'm just cautioning you that the border is so all-encompassing in terms of governmental power that you have to ask questions differently than you would almost anywhere else. I mean, yeah, that's kind of what the situation is. So hopefully that's helpful in you trying to figure out what the right answer is here. Maybe not the answer you want, but what the right answer is. The power of the government at the border is immense. Plaintiffs argue that because electronic devices may contain a trove of sensitive personal information, basic border searches of electronic devices are non-routine searches requiring at least reasonable suspicion. While, as noted above, Riley's warrant requirement in the search incident to arrest context does not extend to border searches. Riley recognized that modern electronic devices implicate privacy concerns far beyond those implicated in the search of a cigarette pack, a wallet, or a purse, and differ both in quantitative and qualitative senses from other objects that might be kept on a traveler's person. Plaintiffs next argue that the border searches of electronic devices must be limited in searches for contraband. This argument is premised on plaintiffs' assertion that border search exception extends only to searches aimed at preventing the importation of contraband or entry of inadmissible persons and covers only searches for contraband relief, rather than for evidence of border-related crimes or contraband. The argument fails, and its premises are incorrect. In non-border context, the Supreme Court has held that warrantless searches must be limited in scope to that which is justified for particular purposes served by that exception. As for advanced searches, we cannot reasonably conclude that substantive limitations imposed by the Constitution on border search exception prevent Congress from giving border agents authority to search for information or items other than that of contraband. Congress is better situated than the judiciary to identify the harms that threaten us at the border. So again, here this is going to the nature of governmental power and what they can do. And here you want Congress's authorization. And the question is, how far can Congress go? What can they authorize at the border? And the answer is nearly unlimited. The power is immense. The power to control who comes into your state, and what comes into your state is pretty immense. So what can Congress do? Their power might be unlimited in that domain. And so the court here is just noting that this is an issue best left to Congress because control of the border is one of those fundamental things sovereigns do. So, yeah. As to plaintiffs' distinction between evidence of contraband and contraband itself, the border search exception is not limited to searches for contraband itself rather than evidence of contraband of border-related crime. Searching for evidence is vital to achieving the border search exception for purposes of controlling who and what may enter the country. As plaintiffs' distinction between evidence of contraband and contraband itself, the border search exception is not limited to searches for contraband itself, rather than evidence of contraband or border-related crime. Searching for evidence is vital to achieving the border search exception purpose of controlling who and what may enter the country. We acknowledge that our holdings of both these points are contrary to the Ninth Circuit's holdings. So the Ninth Circuit and First Circuit disagree with each other, which is always a good basis for a Supreme Court decision. So, hey, that means the increased likelihood of the Supreme Court hearing this has gone up. Circuit splits are classic. So apparently the First Circuit and Ninth Circuit are in disagreement. Maybe the Supreme Court will figure it out. We cannot agree with the narrower view of border search exception because the Cano case of the Ninth Circuit fails to appreciate the full range of justifications for the border search exception beyond prevention of contraband itself entering the country. Advanced searches of electronic devices may be used to search for contraband as well as evidence of contraband or for evidence of activity in violation of the laws enforced or administered. So the Ninth Circuit made a more limited decision. I don't know if conservative is the right word, but they made a more limited decision. They said the border purpose is to prevent contraband, which it certainly is. The First Circuit takes a broader view. It's not just contraband, it's also evidence of contraband, which kind of makes sense because maybe there's text messages or something that relates to contraband or drugs or something. Or emails that are on the device. Anything's possible, right? Or it somehow exposes other criminal activity that might be relevant to what the Border Patrol enforces. So the Ninth Circuit took a more limited view. The First Circuit takes a more expansive view. And I know the Supreme Court will have to figure out that one, so that should be entertaining. If I were a betting man, though, I think the Supreme Court's more likely to take the expansive view because, again, they're more likely to defer to Congress. So if you're looking for this to be constrained by the Supreme Court, I think that's less likely an answer. I think the more likely answer is this is up to Congress to decide and we should defer, which is a perfectly serviceable answer too, although it may not be what we want. But maybe Congress will do something about it. We'll see. Plaintiffs further argue that Customs and ICE's policies violate the Fourth Amendment because they do not impose an effective limit on the duration of electronic device detentions. The policy permits an officer to detain an electronic device or copies of the information for brief, reasonable periods of time to perform a thorough border search. So what that means in practice is anyone's game, though, right? The nature of plaintiff's challenge is unclear. The policies permit detention for only a reasonable period, which is the constitutional test. The Customs policy requires a supervisor's permission to detain a device after its owner leaves the border, a higher level of supervisor approval to extend the detention for longer than 5 days, and a third level approval to extend it beyond 15 days. What is reasonable is surely fact-specific, as further as applied attacks are not foreclosed should there be abuses. So, with sufficient supervisor approval for beyond 15 days. So, that's apparently the reasonable length of time under the current policy, which the court has no problem with. So that brings us to our end of the discussion of the cell phone search issue at the border, as brought to us by Ghassan Al-Saleh versus Homeland Security. In this case, a whole bunch of people had their cell phones searched at the border in an expansive way without a warrant, and they complain. And the First Circuit notes that there is now a division of authority between them and the Ninth Circuit. According to the Ninth Circuit, this kind of search can only be done to prevent contraband, but the First Circuit takes a more expansive view. It can be done to find evidence of contraband as well as other illegal aspects. And so there's a division of authority. Plus, there's also at least some tension with cases such as Riley or Carpenter. Those cases don't directly speak to the point, but then again, they do provide some information. So it's fairly likely the Supreme Court will take this, although certainly not a guarantee, with the circuit split and issues dealing with the border. And as for the rest, we'll have to see. But for the moment, at least, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.